In the southern Philippines, back in May 2017, government security troops led by the Armed Forces of the Philippines in search of the most wanted militant in Silion Hapilon clashed with extremists affiliated with Islamic State-linked Maute Group and the Abu Sayyaf Group. A week later, Defense Secretary Delfin Lorenzana disclosed that around 500 Islamist terrorists have fought in Marawi City. Over 100 deaths have been tallied and thousands of internally displaced people fled Ground Zero during the siege. That violence begs the question. 13 years after the enactment of the Philippines anti-terror law, what has been done to fight this long-standing terrorism in the country? The Human Security Act of 2007, otherwise known as Republic Act No. 9372, was enacted by the 13th Congress of the Philippines. The law took effect on July 15, 2008, providing a legal framework for the government's anti-terrorism strategy and security policies. House Bill No. 2082, which was filed on July 15, 2007, amended Republic Act No. 9272, or the Human Securities Act of 2007. This is to make it rational, balanced, realistic, and truly effective in the fight against terrorism. Unfortunately, at present, the HSA had provided little to zero contribution in the fight against terrorism. To this date, there have only been 2 cases where the HSA had been applied. The first was in the 2008 case of Jun Guevara, where the accused plea bargained and in the prescription of the Abu Sayyaf Group as a terrorist organization in 2015. Currently, the Senate has passed Senate Bill No. 1083, which aims to repeal Republic Act No. 9372, replacing it with an amended version dubbed as Anti-Terrorism Act of 2020. However, pending any amendatory act, the law continues to be an essential tool in securing the state and protecting the people from terrorism. Good day, everyone! We are now on the 5th segment of our report on special penal laws. I am ICI once again and your reporter for today's learning episode of Philippine Laws Dissected. With all the history that we have upon us, we can ask the question, what exactly is terrorism? Terrorism is defined as the premeditated or threatened use of violence or force or any other means that deliberately cause harm to persons or of force and other destructive means against property or the environment with the intention of creating or sowing a state of danger, panic, fear, or chaos to the general public, or segment thereof, or of coercing or intimidating the government to do or refrain from doing an act. It is a crime against the Filipino people, humanity, and against the law of the nations. Who are the persons liable for terrorism? Both natural and juridical persons can be held liable for terrorism, and their liabilities, however, depend on the degree of participation. As such, these are the penalties provided by law. First, a penalty of 40 years of imprisonment without parole is imposed on a principal. For the accomplice, it is a penalty of 17 years, 4 months, and 1 day to 20 years of imprisonment. For an accessory, a penalty of 10 years and 1 day to 12 years of imprisonment. Even mere conspiracy to commit terrorism by these persons shall be punishable, and they shall suffer 40 years of imprisonment without parole. When can terrorism be committed? Terrorism is deemed committed when all of the following elements are present. First, the offender commits an act punishable under any of the following provisions of the Revised Penal Code. These are the following provisions. Article 122 on piracy in general and mutiny in the high seas or in Philippine waters. Article 134A on coup d'etat, including acts committed by private persons. Article 248 on murder. Article 267 on kidnapping and serious illegal detention, and Article 324 on crimes involving destruction. This also includes special penal laws, which are the following. Presidential Decree 1613, or the law on arson, Republic Act Number 6969 or Toxic Substances and Hazardous and Nuclear Waste Control Act of 1990, Republic Act Number 5270 or the Atomic Energy Regulatory and Liability Act of 1968, Republic Act Number 6235 or the Anti-Hijacking Law, and Presidential Decree 532 or the Anti-Piracy and Anti-Highway Robbery Law of 1974. It is important to take note that before a charge for terrorism may be filed under Republic Act Number 9372, a predicate crime must have actually been committed first to trigger the operation of the key qualifying phrases in the other elements of the crime, including the coercion of the government to accede to an unlawful demand. The second element would be the commission of the predicate crime sows and creates a condition of widespread and extraordinary fear and panic among the populace. This condition of widespread fear is traditionally achieved through bombing, kidnapping, mass killing, and beheading, among others. Third, the offender is actuated by the desire to coerce the government to give in to an unlawful demand. Oftentimes, there is confusion between terrorism and rebellion. So what exactly is the difference between these two crimes? Does terrorism absorb or negate rebellion? Terrorism neither absorbs nor negates rebellion. Rebellion may be considered under the crime of terrorism, which has a broader scope covering a wide range of predicate crimes. In fact, rebellion is only one of the various means by which terrorism can be committed. It would thus appear that the crime of terrorism covers an even larger universe of crimes. Apparently, while terrorism does not always amount to a rebellion, acts of terrorism may be committed in the furtherance of a rebellion. The scope of terrorism may be comprehensive. Its purpose is distinct and well defined. The objective of a terrorist is to sow and create a condition of widespread fear among the populace in order to coerce the government to give in to an unlawful demand. In contrast, the purpose of rebellion is political. It is to remove from the allegiance of the Philippine government or its laws, the territory of the Philippines or any part thereof, any body of land, naval or armed forces, or to deprive the chief executive or Congress, wholly or partially, of their powers and prerogative. Which then leads us to question, how can a group, association, organization, or person be declared as a terrorist, or an outlawed association or organization and not as rebels? Well, the difference between the terrorist and the rebel boils down to their intention. Terrorists use fear and violence to advance their agenda or ideology, which may or may not be political in nature, while rebels use violence as a form of strategy to obtain their goal of destabilizing or overthrowing the government in order to gain control over a part or the entire national territory. If rebels succeed in overthrowing the government and install themselves as the ruling party, their status is legitimized by application of the Department of Justice before a competent regional trial court, with due notice and opportunities to be heard given to the organization, association, or group of people concerned. They can be declared terrorist or outlawed association or organization. Now, are there instances that would justify state surveillance? The Bill of Rights itself states that the privacy of communication is inviolable unless a court unlawfully orders it. The anti-wiretapping law says that while it is unlawful to record a conversation without the consent of all the parties, any peace officer with a written court order can do so. The Cybercrime Prevention Act authorizes with just cause to collect real-time traffic data such as the communications device location, but not its content or identity. The Human Security Act, in cases of terrorism, also allows law enforcement officials to intercept or record any communication, message, conversation, discussion, or spoken or written words with the use of any surveillance equipment or of any means suitable. According to J.J. Dissected, What stands between state action and the invasion of privacy is a judge. The government must go to a judge, a court, and ask for permission to engage in surveillance and collect information from individuals. If the state actors sidestep this process, the collection of information would be unconstitutional and punished by law. As such, how does this law keep suspects under surveillance? Upon a written order of the Court of Appeals, a police or law enforcement official and the members of his or her team are allowed to listen to intercept and record any form of communication, spoken or written, between members of a judicially declared and outlawed terrorist group, whether suspected of terrorism or conspiring to commit terrorism, using any mode of electronic or other surveillance, intercepting, or tracking device. Now, are there any exemptions under this rule? Yes, there is. There are exceptions especially enjoyed by those covered by the confidentiality rule. These include surveillance, interception, and recording of communications between, first, lawyers and clients, second, journalists and their sources, and lastly, confidential business correspondence. Provided that there's a necessary requirement of a written order from the court in order to intercept any of the suspect's communication, the question now is, how can a police officer or a law enforcement official obtain such order? An order from the court to intercept communication may be obtained by an ex parte written application submitted by a police or a law enforcement official duly authorized in writing by the Anti-Terrorism Council to file such ex parte application. It is important to note that only the authorizing division of the Court of Appeals may grant such order. The applicant and the witnesses he may produce upon examination under oath or affirmation must establish that there is a probable cause to believe that the said crime of terrorism or conspiracy to commit terrorism has been committed or is being committed or is about to be committed. The evidence which is essential to the conviction of any charged or suspected person for or to the solution or prevention of any such crimes will be obtained, and there is no other effective means readily available for acquiring such evidence. So, for how long is this judicial authorization effective? Now, each judicial authorization has a period of effectivity specified therein, which shall not exceed a period of 30 days from the date of receipt of the written order by the applicant police or law enforcement official. Now, can this be extended or renewed? The answer is yes. The authorizing division of the Court of Appeals may extend or renew for another non-extendable period, which shall not exceed 30 days from the expiration of the original period, provided, however, that the authorizing division of the Court of Appeals is satisfied that such extension or renewal is in the public interest, and that the ex parte application for extension or renewal, which must be filed by the original applicant, has been duly authorized in writing by the Anti-Terrorism Council, who will have custody of these intercepted and recorded communications. Now, the authorizing division of the Court of Appeals shall have custody of the intercepted and recorded communication. The same shall be stored in a sealed package or envelope and be deposited within 48 hours after the expiration of the period fixed in the written order of the authorizing division of the Court of Appeals, or within 48 hours after the expiration of any extension or renewal, and shall be accompanied by a joint affidavit of the applicant police or law enforcement official and his members of his team. Now, the next question would be, what is the succession in the application of judicial authorization and joint affidavit required for the custody of these intercepted and recorded communications? If the original applicant dies, the one next in rank to the original applicant among the members of the team named in the original written order of the authorizing division of the Court of Appeals shall file the application for extension or renewal. The same rule applies for the joint affidavit required in depositing intercepted and recorded communication. If the applicant dies or becomes physically disabled to execute the said required affidavit. It must be noted, however, that it shall be unlawful for any person, police officer, or any custodian of the tapes, disc, and recording, and their excerpts and summaries, written notes, or memoranda to copy in whatever form, remove, delete, expunge, incinerate, shred, or destroy in any manner the items enumerated, in whole or in part, under the pretext of whatsoever. Otherwise, they shall suffer the penalty of not less than 6 years and 1 day to 12 years of imprisonment. The next question under our belt is, what are the contents of the joint affidavit required upon the deposit of the communications? The following information should be seen in a joint affidavit. First, the number of tapes, disc recordings, as well as the number of excerpts and summaries, written notes and memoranda that have been made in connection therewith. Second, relevant dates and times covered by each of such tapes, discs, and recordings. Third, the date of the original written authorization. And lastly, the date of any extension or renewal of the written original authority. It shall also certify under oath that no duplicates or copies have been made of the whole or any part of any of such tapes, discs, recording, or any of such excerpts, summaries, written notes, and memoranda. Otherwise, it shall be included in a sealed envelope or sealed package, deposited with the authorizing division of the Court of Appeals. If any person, police or law enforcement official, shall make any false or untruthful statement or misrepresentation of the material fact, he shall suffer the penalty of not less than 10 years and 1 day to 12 years of imprisonment. For how long may a person be detained under this law? When may his detention be extended? Now, if a detention was done without a judicial warrant, a person may be detained for 3 days, from the moment he was apprehended, arrested, detained, or taken into custody. If, however, that person was apprehended at the event of actual or imminent terrorist attack, he cannot be detained for more than 3 days without written approval of a municipal, city, provincial, or regional official of a human rights commission or judge of any courts nearest to the place of arrest. What are the rights of a person under custodial investigation? As bestowed by our Constitution, the offender shall be entitled to the following rights upon arrest. First, it is to be informed of the nature and cause of his arrest, to remain silent, and to have competent and independent counsel, preferably of his own choice. If the person, however, cannot afford a counsel of his own choice, he can avail of the Free Legal Assistance Unit of the Integrated Bar of the Philippines or the Public Attorney's Office. These rights cannot be waived except in writing and in the presence of the counsel of choice. Second, to be informed of the cause or causes of his detention in the presence of his legal counsel. Third, it is to be allowed to communicate freely with his legal counsel and to confer with them at any time without restriction. Fourth, it is to be allowed to freely communicate and privately without restrictions with the members of his family or with the nearest relatives and to be visited by them. Lastly, it is to be allowed freely to avail of the service of a physician or physicians of choice. If these are violated by a public officer or law enforcer, he shall suffer the penalty of 10 years and 1 day to 12 years of imprisonment. Furthermore, HSA strictly prohibits torture and coercion, investigation and interrogation, for it vitiates free will and considers any evidence acquired through torture or coercion as inadmissible. If found guilty of threat, intimidation, torture, and coercion in investigation and interrogation, the penalty is 12 years and 1 day to 20 years of imprisonment. The same shall be imposed if death or serious disability shall result from such acts. What are the liabilities imposed in case of infidelity in the custody of detained persons? Any public officer who has direct custody of a detained person or under the provisions of this act and who by his deliberate act, misconduct, or inexcusable negligence causes or allows the escape of such detained person shall be guilty of an offense and shall suffer the penalty of 12 years and 1 day to 20 years of imprisonment if the detained person has already been convicted and sentenced in a final judgment of a competent court. 6 years and 1 day to 12 years of imprisonment if the detained person has not been convicted and sentenced in a final judgment of a competent court. In case of conviction of the accused under this law, what restriction shall be imposed upon him, and what may be possibly done to his book of accounts and record? Under HSA, the court shall restrict the accused's right to travel within a municipality or city which he resides or where the case is pending, in the interest of national security and public safety. Otherwise, traveling outside the restricted area without court authorization shall be deemed as a violation of the terms and conditions of his bail. Note that during hearing, any person who shall furnish false evidence, forged documents, or spurious evidence shall suffer 12 years to 20 years of imprisonment. Like any other organization, terrorist groups or organizations need financing not just to fund specific terrorist operations, but to meet the broader organizational cost of maintaining and creating an enabling environment to sustain their activities. This is why the Court of Appeals may authorize in writing any police or law enforcement officer and the members of his or her team, duly authorized in writing by the Anti-Terrorism Council, to first examine or cause examination of the deposits, placements, trust accounts, assets, and records in a bank or financial institution. Second, gather or cause the gathering of any relevant information about such deposits, placements, trust accounts, assets, and records from a bank or financial institution. What happens to the accused if he shall be acquitted because the charge of terrorism was unproven? The accused of having committed any terrorist acts under this law is quite despicable and injures one's reputation. Hence, this law awards liquidated damages in the amount of 500,000 pesos a day for the period in which the properties and bank documents of the acquitted person were seized. The amount will be shouldered by the police agency or law enforcement agency that caused the filing of the charges in relation to terrorism. The seizure, sequestration, and freezing of his bank records, placements, trusts, accounts, assets, and records will be automatically cancelled without any delay, and the said bank documents be returned to him. A motion for reconsideration would not hinder the acquitted his right over the said documents. Otherwise, the public officer who delays the release of amounts awarded shall suffer 6 months imprisonment. It is equally important, once the accused validly prosecuted and has pleaded to the charge is either acquitted or dismissed, it shall be a bar to another prosecution for any offense or felony, which is necessarily included in the offense charge under this law. That means, if he is acquitted for the crime of terrorism by committing rebellion, he cannot be prosecuted further in any other offense or felony enumerated in this law. What are then the requisites for the application to examine books, accounts, and records? There must be an ex parte application of a police officer or law enforcement duly authorized by the Anti-Terrorism Council. It should be made upon examination under oath of the applicant and the witnesses he may produce to establish the facts that will justify the need and urgency of examining and freezing the bank deposits, placements, trust accounts, assets, and records of the person charged with or suspected of the crime of terrorism or conspiracy to commit terrorism, a judicially declared and outlawed terrorist organization, association, or group of persons, and lastly, any member of such organization, association, or group of persons. What is the evidentiary value of the deposited, intercepted materials and bank materials in the judicial proceeding? All those deposited materials, even those that are secured in violation of the law's pertinent provisions, shall absolutely not be admissible and usable as evidence against anybody in any judicial, quasi-judicial, legislative, or administrative investigation, inquiry, proceeding, or hearing. So, does HSA follow the territoriality principle of criminal laws? Criminal laws in the Philippines generally follow the territoriality principle. That means a criminal action should be filed in the place where the crime was committed. However, it admits some exceptions that allow extraterritoriality, and HSA is one of it. Can this law be facially challenged on the grounds of void for vagueness and overbreadth doctrine? A facial invalidation of a statute is allowed only in free speech cases, wherein certain rules of constitutional litigation are rightly accepted, but not in HSA. In Estrada v. Sandigan Bayan, with GR number 148560, November 19, 2001, the Supreme Court said that a facial challenge is allowed to be made to a vague statute and to one which is overbroad because of possible chilling effect upon protected speech. This rationale, however, does not apply to penal statutes. Criminal statutes have a general terrorism effect resulting from their very existing, and if facial challenge is allowed for this reason alone, the state may be prevented from enacting laws against socially harmful conduct. In the area of criminal law, the law cannot take chances, as in the area of free speech. It is a vision of our country to be terrorist-free. While this act still has a lot to prove in terms of efficacy, we can improve and keep up with the changing times by addressing the gaps, lapses, and inadequacies. So, this ends today's episode of Philippine Laws Dissected. See you next time.